Hi everyone, in this video we're going to have a look at the Human Rights Act 1998. We're going to be evaluating the key sections that you need to know if you were to have an essay on this in your exam. So just a quick overview. So the Human Rights Act 1998 was introduced to allow individuals to argue cases involving rights contained in the European Convention on Human Rights directly before a court. So it incorporated the European Convention on Human Rights into domestic law. So as we're going to see in a second, before the Human Rights Act came into force in 2000, individuals could not rely directly on convention rights before UK courts. The judges could only use the convention to aid interpretation in cases where the law was ambiguous. So the Human Rights Act allows any person within the UK to bring a case against a public body, including the courts, for a breach of convention rights. So that brings us up to our first point here. So Section 7. So Section 7 lays down who is allowed to bring a case to a court or tribunal in the UK. So a person claiming under the Human Rights Act can bring proceedings and rely on the convention rights if they are a victim of an unlawful act by a public body. So they do have to be directly affected by an act or measure of a public body in order to have standing in legal proceedings under the Human Rights Act. They cannot do it on behalf of someone else, for example. So this is really important as it gives people in the UK the right to enforce their human rights in domestic court, so in courts in the UK. As I just mentioned in the introduction, before the Human Rights Act, if you wanted to rely on your convention rights, you'd have to go to the European Court of Human Rights. This was a very expensive procedure, it was a very stressful procedure, and it would take a long time as well, up to about 6 years, because as I said in my previous video, the European Court of Human Rights hears cases from all of its member states. So Section 7 is really important because it allows individuals the right to enforce their rights within the UK. It doesn't, however, remove the right to appeal to Strasbourg. You still are allowed to apply to the European Court of Human Rights only when all domestic remedies are exhausted. So once you've gone to the Supreme Court, if you're still not happy with a decision, you can appeal to the European Court of Human Rights. So a very important section of the Act. The next section we're going to have a look at is Section 6. So Section 6 I'm going to split up into two slides. So the first slide we're going to have a look at the definition of public authorities and the issues that come with that. And then the second slide we're going to have a look at horizontal effects. Okay, so Section 6 of the Human Rights Act sets out which bodies are bound by the Act. So like the European Convention on Human Rights, the Act is only able to be applied to public bodies carrying out public functions. This is often described as a vertical effect between an individual and the state, which we're going to have a look at in just a second. The issues that come with Section 6 is that there's no clear definition of public authorities set out in the Human Rights Act. It only notes that it's persons or bodies whose functions are of a public nature. So we have got two different types of public authorities. You've got your core public authorities. These are things like the NHS, the police force, fire brigade, your local council. Courts and tribunals are also included in this, which is what we're going to have a look at in a second. And these are easily identifiable. There's no issues with this. They are established purely to perform a public function, and they are public authorities for the purpose of Section 6. The issues come about with regards to hybrid public authorities. So these are bodies that are private in nature but public in function. So these are becoming a lot more popular. The function is being contracted out to private bodies. So for example, residential care homes or social housing, they might have a private landlord or a private company owns the care home, but they're performing a public function. So there have been some criticisms of the lack of definition, and there have been calls for further legislation to provide a definition of public authority. But for now, it has been left to the courts to decide when the Human Rights Act applies. So when there is seen to be a public authority when it comes to a case which involves a hybrid public authority. So we're going to have a look at two cases for this and see two different approaches when it comes to defining hybrid public authorities. So the first case we're going to have a look at is Donoghue and Poplar Housing. So in this case, a narrow interpretation was given which restricts the application of the Human Rights Act. In this case, when deciding whether a housing association was a hybrid public authority, the court used an institutional approach. It examined how the body itself related to the state rather than what it actually did in regards to its functions. So it didn't look at its functions, it just looked at the relationship it had with the state. However, this was then inconsistent with the case of Parish of Aston Cantlow and Wallbank. In this case, the courts decided to take a wider approach when looking at the nature of the body. So they had a look at things like whether it was supervised by the state, how it was funded. If it was obviously publicly funded, it'd be more likely to be seen as a hybrid public authority. Was there a public interest in the functions? Was it serving a public interest rather than profit? These kind of things. So there is a wider interpretation of hybrid public authorities and a wider definition of hybrid public authorities for this case. You can also have a look at the case of YL and Birmingham as well. That's another case that looks at the definition of hybrid public authorities. So, evaluation of this point. It is clear that the law isn't clear enough, okay? As I said before, there have been calls for further legislation to define public authorities when it comes to hybrid public authorities. But then you could argue, on the other hand, it is good that there is no clear definition because it does allow for this wider interpretation, such as in Cantlow. But it does mean there are different decisions. So obviously Donoghue and Poplar, a very narrow approach, whereas Cantlow is a lot wider. So there is some criticism as to the decisions being made related to hybrid public authorities because there's not much consistency within them. Okay, so that's the definition of public authorities, and that there isn't a definition, which causes some contentious case law. The next thing we're going to have a look at is horizontal and vertical effect. So let me just go through horizontal and vertical effect as a quick overview. It's not as complicated as it sounds. Vertical effect, quite simply, is when an individual brings a case against a public authority or the state. Okay? The state has more power, it's up here, and there is a vertical effect. So in the Human Rights Act, an individual is able to sue a public authority or a public body. That is a clear vertical effect. However, the issue comes about when there is an individual and an individual. This is known as horizontal effect. It's been argued that the Human Rights Act creates an indirect horizontal effect. So this is where the Human Rights Act indirectly influences the decisions made in a court or tribunal between private parties. So the two private parties here, the individual and the individual, if, for example, this individual here, let's call them A, is complaining about an invasion into their privacy by individual B, who is a newspaper, the public authority, or the court in this case, because the court is a public authority for the purposes of Section 6, the public authority has to balance the rights between individual A and individual B. If they don't, if the public authority, the court, doesn't do this and favours one right over the other, then they are in breach of the Convention and the Human Rights Act. Therefore, it creates this this horizontal effect indirectly. So the court or the tribunal is not allowed to make a decision that's incompatible with the Convention on Human Rights. So they do have to be very aware of balancing the rights in private cases. So let's have a look at an example of this. So there we are. My point here is Section 6 binds courts. So there have been cases where there has been indirect horizontal effect in private cases, because the court has to balance the rights of two individuals. If they don't do so, if the court doesn't do so, then they would be in breach of the convention themselves, and they could be liable to be sued. So a case in this is Douglas and Hello. In this case, the court had to balance the right to privacy of Douglas, the complainants, of Article 8, and then the Article 10 right to freedom of expression of the respondents, Hello, the magazine. So it shows in this case that the court has to engage with the Human Rights Act, has to be aware of the convention rights, otherwise they would be in breach of their duties under the Human Rights Act and Convention of Human Rights. Okay, so very, very quickly, just to go over that again, horizontal effect is between, two individuals. However, because a court is a public authority for the purposes of Section 6 Human Rights Act and the European Convention of Human Rights, the court is bound to balance the rights of the two individuals, so the rights to privacy versus the right to freedom of expression, for example. Okay, Section 2 then. Section 2 of the Human Rights Act ensures compatibility with human rights laws in Europe. So it ensures that the court or tribunal considering a human rights case under the European Convention and the Human Rights Act must pay due consideration to previous decisions, judgments and opinions of the European Court of Human Rights and the European Commission. So Lord Bingham in Ola 2004 said that it's the duty of the national courts to keep pace with Strasbourg jurisprudence as it evolves over time. No more, certainly not less. Okay, so the evaluation of this is that some people have criticised this by saying it gives too much thought to European decisions, with many people believing that any decisions that could affect the British Constitution needing to be purely British. So those are the ones who would disagree with this section, and they would say that this needs reform because if we are in Britain, we should be making our own laws. We should not be going to the court of human rights in Strasbourg and relying on what they decide. However, Section 2 does allow for consistency among the courts in the UK and has allowed the easier incorporation of the European Convention in domestic law. Okay, the next point we're going to have a look at is Section 3 of the Human Rights Act. So Section 3 of the Human Rights Act allows judges wider interpretation rules. So under Section 3, primary and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights as far as this is possible to do so. This has led to greater powers of interpretation than what existed pre-1998 Act. And it has led to some contentious decisions being passed. So one such case is Guiden and Goda Mendoza, which clearly indicates how Section 3 can be used to modernise laws through wider interpretation powers. So in this case, the judges decided to read as his wife or husband to include homosexual couples. So it was read in a way that it said as if it were his or her wife or husband. Obviously, at this time, this was 2004, gay marriage was still not legal. This was read in such a way to avoid a decision incompatible with Article 14 of the European Convention, which is the right not to be discriminated against. However, Lord Millett did dissent, and in his dissenting judgment, he clearly echoed the many criticisms of the judiciary's use of this power. So this links us in with our evaluation. So many believe, including Lord Millett himself, that this power should not be used in a way to change the meaning of the law itself, and that judges should not demonstrate a quasi-legislative function. Okay, it's not their role to change the law, it is merely their role to interpret the law. So they said instead, where this interpretation clause cannot be used without changing the meaning, a Section 4 declaration of incompatibility should be made instead. So that was Lord Millet's argument in this case. He agreed that the law was incompatible with the European Convention of Human Rights, but it shouldn't be read in such a way that it was made compatible. It should instead have been subject to a declaration of incompatibility under Section 4. Okay, let's have a look then at Section 4. We're going to have a look at Section 4 and Section 10 together. So where a judge cannot interpret the law in such a way that it becomes compatible with the European Convention, he or she may declare a law incompatible under Section 4. So I'm going to go down to Section 4 here for your explanation, evidence valuation. So Section 4 can be argued to be a benefit as it brings incompatible law to the attention of the government, such as in the case of Bellinger and Bellinger. It was also used in A and others as well. Okay, so those are two cases you can have a look at for this. So Section 4 does not mean that the law is struck out. The courts still have to apply it. So this is a weak point. Even though the law is incompatible with the European Convention, the courts still have to apply the law, but they do just have to tell the government, tell Parliament that it is incompatible. Section 7 of the Human Rights Act then gives the power to take remedial action. So after a declaration of incompatibility has been held, if a minister considers that there are compelling reasons to do so, he may make amendments to the legislation necessary to remove the incompatibility. So good. Section 4, the courts have said that the law is incompatible. Section 10 gives a minister the right to improve the law to make it compatible. However, it's often very difficult to find a compelling reason in order to use Section 10, which negates the usefulness of Section 10 and make it incompatible legislation compatible with the European Convention on Human Rights. So the idea is there, but it's not quite put into practice as well as it could be. Okay, Section 19 then, nearly there. So under Section 19, compatibility with the European Convention should also be considered when drafting new legislation. So this makes sure that any new laws are compatible with the European Convention on Human Rights. However, it is not compulsory to make a statement of compatibility, because an MP may also make a statement to the effect that although the bill is incompatible with the European Convention of Human Rights, he still wishes the House to proceed with the bill. So this almost renders null Section 19. So consideration does have to be made to the European Convention of Human Rights. However, a statement of incompatibility setting out why the bill is not compatible with the Convention rights and why the government wishes to proceed with the bill is still allowed. So a Parliament can pass an act which may be incompatible with the Convention rights as long as it's stated that it is incompatible. So Section 19, this statement is designed to ensure proper human rights scrutiny of a bill. Okay, so even though it's not always perfect, even though laws do pass that are not compatible, it does allow for that extra level of scrutiny. Okay, so that's done. Any questions, just give me a shout. So those are your key sections with some evaluation. Make sure you're going over the cases and ensuring that you understand why each section is important and how effective it is or not so effective it is. Thank you. Bye-bye.